right, hello everyone. Good evening. So welcome on this foggy Wednesday evening in January. My name is Nagai Pindell, and I'm the Dean of the Allard School of Law, and it's my honor to welcome you to this year's 2026 Marlee Kline Lecture in Social Justice. So before we begin today's program, I would like to acknowledge the UBC's Point Grey campus is located on the ancestral and unceded territory of the Musqueam people. I'd also like to point out that we are joined by many people on Zoom today, online. So those people are joining us from many places, near and far, and they might take a moment to think about and reflect the owners and original owners and caretakers of the lands that they're joining us from. So my role here today is brief. First, I have some housekeeping issues, especially for the folks on Zoom. And then I will introduce Professor Deborah Parks, who will say a few words about Marlee Kline, and our speaker for today, Natasha Bakht. So first on the housekeeping items, if you experience any technical difficulties online, please reach out to or via Zoom chats for assistance. Please be sure to direct your questions to the host. We have additional colleagues on the line whose webcams are turned off, but they are assisting on the back end. We will have a short Q&A following this lecture. For folks online, please, if you have questions for the speaker, please use the Q&A box to submit them. And now it's my pleasure to invite Professor Deborah Parks to the microphone to share more with you about, as I said, Marlee Kline, and to introduce our speaker. Professor Parks is a scholar of constitutional and criminal law with a particular focus on structural inequality and its manifestations in sentencing and punishment. She is also no stranger to the Center for Feminist Legal Studies. She holds the law school's chair in feminist legal studies and served as director of the center from 2017 to 2021. And she was also a student at the law school when the center was first founded. I'll say the year. I was a student. 97. I too was still a student. I just graduated, but 96, but 97. So please join me in welcoming Professor Parks.
Thank you, Dean Pindell, and it's a real pleasure to be able to even speak briefly at this really special and important event in our annual calendar. I have the honor to say a few words about Marlee Kline. She joined the law school here at UBC as a faculty member in 1989. Where she continued as a beloved teacher, scholar, colleague, and mentor until she died far too young at the age of 41 in 2001. Professor Kline was deeply committed to critical, challenging, and engaged study of law and legal institutions. Her work reflected a passionate belief that social justice must play a central role in legal education and law. Her scholarship was groundbreaking and impactful. It remains deeply relevant today. She wrote on feminist legal theory and critical race theory, child welfare law and policy, and continuing effects of colonialism and restructuring of the welfare state, as well as on anti-Semitism. Professor Kline was a dedicated and inspirational teacher who provided support and extensive feedback to students. She had such a significant impact on many students, particularly those who are marginalized and who were, we often talk about sort of outsiders to law and people who were from, students who were from groups that had historically been underrepresented in law. Within the faculty, Marlee worked very hard to make the faculty a welcoming place for students, particularly Indigenous students, worked hard to strengthen at the time, the First Nations law program, now Indigenous Legal Studies, as well as the strength in feminist legal studies at this law school. I was a student here in 1994 to 97, and I knew and deeply respected Marlee, but I regret deeply never having been a student in one of her classes. I still assign her her work to my students in my classes now. Marley was also an accomplished dancer, something that she shares with our speaker tonight. Some of the concrete manifestations of Marley's legacy include an annual essay prize for student papers that bring an intersectional feminist lens to legal questions, and a wonderful physical space here on the fourth floor. It's called the Marlee Kline Room, and it is the heartbeat of the Center for Feminist Legal Studies, a place for students to gather and exchange and drink tea, and for our visitors to also, and faculty members to be. Another piece of her legacy is, of course, today's lecture. And it is my pleasure to introduce this year's Marlee Kline lecturer, Professor Natasha Bakht. Professor Bakht is a full professor of law at the University of Ottawa. She has held the Shirley Greenberg Chair for Women in the Legal Profession. She held that from 2020 to 2024. She's also called to the bar in Ontario. She served as a law clerk to Justice Louise Arbour at the Supreme Court of Canada. She has an incredible record of publication, and her research interests in law range from law, culture, and minority rights, and specifically the intersection of religious freedom and women's equality, which she'll be speaking about today, as well as a great deal of expertise in family law. Professor Bakht, though, is also an award-winning dancer and choreographer, particularly in the field of Indian contemporary dance, and she has choreographed and danced pieces in relation to law, and giving life to legal concepts and ideas such as discrimination and equality in artistic form. I had the privilege of being at one of those dances a number of years ago at a conference on women's equality, and it was an incredible event. I think everybody who was there deeply remembers the way that she brought to life the concepts that we were wrestling with in a cerebral way, in an artistic way. She's truly a creative, original, and thoughtful scholar, and one of Canada's leading lights in bringing an intersectional feminist lens to all her work: research, teaching, public engagement, and art. So please join me in welcoming Professor Natasha Bakht.
Good evening, everyone. Can you hear me? Okay, wonderful. Thank you so much for that really generous introduction, and for the privilege of speaking at this very distinguished lecture honoring the late Professor Marlee Kline. I never had the opportunity to know Professor Kline personally, but her groundbreaking scholarship have really profoundly shaped my research and writing. Her work moved legal theory beyond single access frameworks, illuminating how multiple forms of discrimination intersect and really compelling the law and scholars to respond to the complex realities of inequality. So my research lies at the intersection of religious freedom and women's equality, an area that is really deeply informed by the principles that Professor Kline championed. In Canada, I've explored the political, legal, and popular objections to Muslim women's dress, and that's what I'll focus on today. It is sort of astonishing that in the 21st century, women's clothes are still the subject of such attention. And yet, the fact that some Muslim women cover their hair with a hijab or cover their faces with a niqab remains a site of controversy, leading to explicit discrimination. The issue is, unfortunately, I guess, or fortunately, depending on your perspective, not uniquely Canadian. It is part of a transnational trend with hijab and niqab bans spreading across numerous countries, recycling similar justifications and tactics, irrespective of local context or logic. So my plan for today is to tell you about what Law 21 is, including its purported rationale, and some history, and then to discuss the impact of this law on visibly religious minorities in Quebec, I'll then turn to how we might legally challenge Law 21. And I'd like to finally discuss Section 33, or the notwithstanding clause in the Charter, which in my mind is the real threat to our commitment as a nation to principles of equality, diversity, inclusion, accessibility, and decolonization principles. So, in 2019, the province of Quebec enacted an act respecting the laïcité of the state, otherwise known as Law 21. And this law restricts the wearing of religious symbols in certain positions in the public service. In other words, a broad range of public employees, including teachers, principals, police officers, lawyers, and judges, and some other civil servants, cannot wear religious symbols such as kippas, turbans, hijabs, niqabs, while performing their jobs. And there is a grandfather clause for those who already had jobs in the public service before the passage of the legislation, meaning that they are exempt from the prohibition on wearing religious symbols, but they can never be promoted or transferred from their positions. So to put this in more concrete terms, if you were a law student in Quebec who discovered that you had a passion for criminal law, and you dreamt of becoming a prosecutor once you graduated, but if you happened to wear a hijab, you would not be able to work as a prosecutor. The law additionally requires people who cover their faces, and the law doesn't specify, doesn't name who these people are, but of course these are Muslim women who cover their faces with a veil known as the niqab. They are forbidden from receiving public services unless they remove their face veils. Now, a little bit of history. You may recall the Bouchard-Taylor Commission in 2008, which had a mandate to examine questions related to reasonable accommodation for cultural or religious differences in Quebec. Following the report of the commission, which recommended that judges, Crown prosecutors, prison guards, and police officers refrain from wearing religious attire or symbols, since that report, there have been 4 attempts in the province of Quebec to amend the Quebec Charter of Human Rights and Freedoms. So in 2012, Bill 94 was tabled, making it mandatory to have a naked face in order to provide or receive services from the state. In 2013, Bill 60, also popularly known as the Charter of Values, proposed a limit to wearing of conspicuous religious symbols for public sector employees. In 2015, Bill 62 became law, requiring uncovered faces when providing or receiving public services, including those in government departments, public transportation, health services, and child care centers. The implementation of Law 62 was suspended while the law's constitutionality was tested through the courts. And as I noted, in 2019, Law 21 was enacted, which extends the reach of Bill 60 and Law 62 to include banning religious symbols for a wide range of public service employees, and to also prohibit people from covering their faces while receiving a public service. Now, you might wonder, what is the rationale behind these attempts to amend the Quebec Charter? Well, the Quebec government has said that it is to promote a vision of secularism where the separation of state and religion is affirmed, religious neutrality is mandated, that is, to ensure that the state is seen as neutral and not favoring one religious community over another. And also, the government claims that it is to ensure the equality of all citizens. So the legislation seems to posit that people who wear religious symbols are advertising their faith and that they are not able to be or appear to be neutral. That is, that they will likely impose their religious beliefs on others. Now, that legislative assertion is, of course, unproven, and it makes negative assumptions about people's abilities to perform their employment duties without religious bias. Arguably, it's only religious prejudice that would lead one to the conclusion that you couldn't get fair treatment from a person of some identifiable religion. Moreover, the idea that a person wearing a religious symbol identifies the state with their religion is, I think, only plausible where the state requires the wearing of a particular symbol, not where the state simply permits it. Nonetheless, we see politicians in Quebec drawing directly from France in its ideas about strict secularism that have essentially come to mean limits on religious expression in the public sector. That Law 21's preamble also highlights the importance of equality between women and men, likely addresses the government's concerns about religious attire, like the hijab and the niqab, and their perceived impact on gender equality. While the hijab is much more commonly seen, the niqab or the face veil is, I would say, encountered much less frequently in Canada, and its peculiarity to some and associations with theocratic or authoritative regimes for many people make it a testament to the oppression of Muslim women and an affront to gender equality. Perhaps the most commonly heard opposition to the niqab is that women cover up at the command of domineering men, and as such, the veil is a sign of Muslim women's oppression, as well as a general indicator of the backwardness of Islamic culture. The niqab is described by its detractors as anti-woman, a mobile prison, or the most misogynistic apparel on earth, one that stamps women as physical possessions to be protected from the supposed sexual depravity of men. And certainly, Quebec politicians have insinuated, if not openly expressed, such views. They have deliberately not listened to the thoughtful and articulate expressions from niqab and hijab wearing women that counter the idea that their clothing is inherently an affront to an abstract idea of gender equality. These are women who have made the profoundly personal decision to lead a faith-based life, yet they are assumed to have an autonomy deficit, and the legislation is implemented for their own good. Sexual liberation and its apparent connection to gender equality also appears to be central to the objection to the niqab on the basis of gender equality. Muslim women's refusal to engage in normal protocols of interaction between men is taken to be sexually aberrant and disturbing. The uncovered face stands for the visibility of the entire body, and more importantly, its sexual availability to men. Dr. Shireen Razak has argued that niqab bans are a command to Muslim women to yield to sexual and racial superiority. So let me turn to the effects of Law 21. Muslim women, and indeed all visibly religious minorities, have been living with the damaging and ongoing effects of Law 21 in Quebec since 2019. While the law impacts all visibly religious minorities, the Quebec Superior Court found it had a particularly cruel and dehumanizing impact on Muslim women. And this is, of course, particularly the case since only niqab-wearing women are denied the receipt of public services. The effects of Law 21 include enduring the devastating consequences of the inability to work in a public service of one's choice, despite expertise and despite training. In spite of popular misconceptions that niqab-wearing women do not or cannot work in the paid labor force, in fact, many Muslim women who wear face veils need to economically support themselves and their families and want to advance a career, earn a living, and contribute to society. And this is, of course, true for all religious minorities. Many visibly religious minorities are studying at university with a view to eventually working in Quebec. And with the Quebec government being a major employer in the province, the inability to work in the public service is a substantial disadvantage. Compared to the private sector, and indeed despite Law 21, the government has actually been a progressive employer, willing to make accommodations for some minority communities, including on the basis of disability. The ability to earn a living, to have some economic autonomy, gives women the freedom to make choices contrary to the wishes of those who are closest to them. So if it were true that niqab-wearing women were being forced to wear the niqab by their parents or their husbands, and incidentally, there is research in 7 liberal democracies that demonstrates that these women choose to wear the niqab despite what their families may want. But if it were true that they were being forced, limiting their economic choices would not enable them to free themselves from these situations. Bans of religious clothing simply erect barriers that prevent minorities from participating fully in society, making their lives much more arduous. Several reports examining the impact of Law 21 note that many individuals experienced discriminatory interactions on a regular basis. Wearing a hijab was a particular flashpoint for verbal attacks in public and has become much more so since the passage of Law 21. In a survey conducted of Quebec students in law and education, experiences of discrimination were felt by students of Muslim and or of Arab background, and Jewish students also commented on experiencing increased anti-Semitism. Teachers trained in Quebec, many of whom are hijab-wearing women, but also Sikh women who wear the dastar, are now moving to other provinces in order to be able to work and advance careers of their choosing. Notably, Law 21 also seems to be having an impact on the residence choices of people who don't wear a religious symbol, but are departing Quebec as a signal of dissent. Students have expressed fear regarding their employment prospects in the province, including disruptions to their career paths, with some stating that they had been planning to study education or law, but are now changing career directions. The denial of state services, whether an outright denial for those who cover their faces or where the receipt of services is likely to be applied in a discriminatory manner, will affect many aspects of niqab-wearing women's lives. We know that women experience higher rates of poverty, and thus they are more likely to require public services, such as public transportation and social assistance. Because women continue to be the primary caregivers for children, the elderly, and those who are ill or who have disabilities, they will also be acutely impacted by the requirement that an individual must show her face in order to access daycare, public retirement homes, public therapeutic services, and hospitals, not to mention transportation in order to reach these services. In the constitutional challenge to Law 21, the Quebec Court of Appeal characterized the requirement to uncover one's face to receive public services as a temporary measure. So the court minimized the impact by noting that niqab or burqa wearing women need only briefly remove their face veils for identity verification or security purposes, after which they can access the service with the face covered. So because the intrusion is momentary, the court deemed it sufficiently tailored. By that logic, if the government required brief exposure of a woman's breast to obtain a service, it could justify it as just for a moment. Limiting niqab-wearing women's access to public transportation and important health and social services will likely isolate them, hampering their free movement and access to friends and family and colleagues, thus potentially leaving them more vulnerable to the everyday violence that we know women of all backgrounds in Canada face. The Quebec government has now passed legislation that prohibits students and staff from having their faces covered while in schools. The denial of multiple levels of educational services will affect the long-term prospects of niqab-wearing women. Access to education is widely recognized as integral to fostering gender equality and the alleviation of poverty. Having an education plays a pivotal and transformative role in the empowerment of women in their ability to earn an income, whether inside or outside of government. Education, we know, reduces poverty, promotes economic agency, and it increases the likelihood of having a healthy life. It's also an essential tool for personal development, equipping women with the capacity to claim and exercise significant autonomy. Moreover, for many immigrant women in Quebec, learning the French language will be a valuable pathway to gender equality. Being denied publicly available French language courses is a significant disadvantage in a primarily French-speaking province that will restrict many prospects for niqab-wearing women. So some of the most fundamental prerequisites to women's well-being, success and equality, access to education, ability to earn a living, autonomy to travel, are thwarted by Quebec's legislation. But perhaps most gravely, by enacting legislation that promotes distrust and animosity towards a specific group of people, there are implications even beyond the legislated text. In Quebec, it has implicitly condoned the segregation, marginalization, and exclusion of minority communities, creating an atmosphere where they are subject to harassment and violence as they occupy and travel through public spaces. It has created an acceptance of the rejection of those who live visibly religious lives and an insistence that they do not belong to Canadian society. The law, of course, shapes the way the public views minority communities, and it legitimizes negative attitudes and behaviors toward them. Reports of harassment, vandalism, hate crimes, insults against Muslims, for example, multiplied in the months after Bill 60 was introduced. Ordinary people are emboldened by the government's backing of these exclusionary ideas, and they act as vigilantes, taking it upon themselves to enforce the law upon Muslim women. And the exclusionary power of this unjust law has created a culture of discrimination such that Muslim women are prohibited from wearing the clothing of their choice in employment sectors even beyond the parameters of Law 21. The National Council of Canadian Muslims released a report that demonstrates that Law 21 exceeds its legal reach on a regular basis, such that Muslim women in Quebec are facing increasingly hostile work environments inside and outside of the public service, including Islamophobic discrimination, physical threats, and aggression at work. These experiences negatively influence minority communities' everyday experiences of belonging, contributing to a growing vulnerability about their safety whilst engaging in even the most mundane of activities. And the underlying consequences of this violence helps to maintain women and minorities generally in subordinate roles. It contributes to low levels of political participation and even lower levels of education, skills, and work opportunities. Okay, that's the impact of the law. Typically, a law like Law 21 in Quebec would never withstand constitutional challenge, since the Canadian Charter of Rights and Freedoms protects such rights as religious freedom, the right to equality, freedom of expression. Significantly, though, and as I'm sure many of you know, the government of Quebec invoked Section 33 of the Canadian Charter and its equivalent in the Quebec Charter, Section 52, to preemptively immunize the law from typical avenues of challenge. So Section 33 of the Charter is called the notwithstanding clause because it permits Parliament or provincial legislatures to make laws notwithstanding certain rights and freedoms that are guaranteed in the Charter. And specifically, those rights are Section 2 and Section 7 through to 15 of the Charter. Section 2 refers to fundamental freedoms, so freedom of expression, freedom of religion. Section 7 through to 14 are legal rights, such as the right to counsel, and Section 15 is the right to equality. So once invoked, the notwithstanding clause prevents a court from declaring the legislation invalid for the 5 years that it is invoked, despite any inconsistency with the Charter. Now, despite the predominant view amongst legal scholars that Law 21 is discriminatory, and a finding by the Quebec Superior Court that it has a cruel and dehumanizing impact on Muslim women, the law continues to stand. Now, lawyers have made a variety of creative arguments to challenge the law in spite of the invocation of Section 33. The Quebec Superior Court decided in Huck, and Huck is the name of the case. It's actually got a couple of different names. We'll call it Huck for now. That's the Law 21 case that's being challenged through the courts. The Quebec Superior Court upheld most of Law 21 in spite of the invocation of Section 33, or perhaps because of. The case then made its way to the Court of Appeal for Quebec, and the Quebec Court of Appeal in Huck upheld all of Law 21, framing the case not as a violation of human rights, but as a divergent vision of society as regards to religious symbolism. So the Court of Appeal offers an interpretation of Law 21 that appears reasonable in its goal of ensuring a secular state, one that is limited. Indeed, to quote them, it is meticulously calibrated in its prescription of religious symbols. In my reading, and I think you have a sense of my biases by now, so that's good, the Quebec Court of Appeal, in my view, seems to praise the government, noting that a hallmark of the act is that it specifically targets what it purports to apply to. The only time that the court suggests that Law 21 might derogate from the Constitution is in the context of its application to judges and the consequent impact on judicial independence. And I'm going to come back to this shortly. All of this has led to what I see as a normalization of discrimination and oppression against religious minorities, Muslim women in particular. And time seems to have blunted our outrage. There have been and continue to be protests about Law 21, but they are really not as deafening as I would like to see. We don't see enough civil disobedience from organizations with power to counter this unjust law. If anything, what we are seeing is a change in perceptions of acceptable political behavior and an increasing willingness to sacrifice core constitutional and social values for the sake of partisan gain. Okay, so what can be done about Section 33? Let me turn to Section 33, which, as I said, I think is the real culprit when it comes to undermining our constitutional rights and values. So Section 33 has been in our Constitution since the creation of the Charter in 1982. Political lore has it that the notwithstanding clause came about because of a historic compromise between the first ministers, except for Quebec's René Lévesque and the Prime Minister. The inclusion of the notwithstanding clause was necessary to enable Canada to patriate its constitution from England and to constitutionally establish a Charter of Rights and Freedoms. Many have argued that Section 33 preserves and gives effect to Canada's tradition of parliamentary supremacy by ensuring that Parliament always has the theoretical last word. Until recently, I'd say about 2018, there was a culture of restraint on invoking Section 33. Political commentators predicted that governments would rarely use the section, and if they did, it would be to their political peril. With the rise of right-wing populist governments that promote, among other things, an anti-Muslim, anti-immigration, protection of traditional values agenda, we are seeing a normalization of the use and renewal of Section 33 of the Charter with no apparent limits. And this has produced a corresponding normalization of inequality. The use of Section 33 as an everyday tool by governments to just bypass fundamental constitutional rights has and will continue to have extremely harmful repercussions for marginalized communities. While the province of Quebec used Section 33 in a blanket manner early on in our charter history, that usage could be characterized as a political protest against the patriation of the Constitution without Quebec's consent. But that use is quite different from the way it is being used now. In 1982, Quebec did not utilize the override section in the Quebec Charter of Human Rights and Freedoms, which arguably offers even greater, broader protections to Quebecers than the Canadian Charter. But with Law 21, Quebec has invoked both override provisions, Sections 33 and 52 of the Canadian Charter and the Quebec Charter, respectively. So what we're now witnessing is, I think, a protest against the very concept of entrenched rights and freedoms. Now, the Charter is, for many Canadians, a justice-seeking document. It promises a better future, a more inclusive society for everyone, irrespective of immutable differences. It advances widely held Canadian values, and an untrammeled opt-out violates, I'd suggest, the Canadian culture of human rights. There's undoubtedly polling data out there about Canadian pride in the Charter and respect for human rights. But even absent political opinion, I think the legitimacy of a modern democratic state depends on its adherence to a bottom line of fundamental norms below which executive action cannot go. And I believe the Canadian Constitution contains an irreducible minimum core of human rights that transcends the political compromise embedded in Section 33. And I think for most people, this feels intuitively correct. If it were not the case, historic injustices that we are only just coming to terms with could easily be repeated for the sake of political will or convenience. Indeed, the invocation of Section 33 could hypothetically permit Canadian governments to replicate human rights abuses that are now universally decried. Indian residential schools, the Chinese head tax, the internment of Japanese Canadians. These are each episodes in our history that the federal government has officially apologized for, promising to do better in the future. But those historic tragedies would today be described as clear violations of the right to life, liberty, and security of the person under Section 7, and to equal protection and equal benefit of the law without discrimination based on race, nationality, or ethnic origin pursuant to Section 15. But Sections 7 and 15 of the Charter are subject to the notwithstanding clause, meaning there is nothing preventing provincial, territorial, or federal governments from using Section 33 to repeat the mistakes of our past by simply ousting key sections of the Charter for a 5-year period. An understanding of Section 33 as unlimited in scope could permit these tragedies to reoccur without legal redress, without constitutional condemnation. Governments could even exclude certain religious groups from public education, deny life-saving medical treatment to trans youth, engage in mass deportations of lawful migrants. Now, if you think, oh, these possibilities seem a bit far-fetched, consider that each of these things is either happening now in a democracy or has been proposed by a major political candidate. And if your immediate response is that our law couldn't possibly allow this, I'd suggest that that reflects an intuitive understanding that such atrocities are not only politically unacceptable, they are legally impermissible. In other words, the Constitution contains an irreducible minimum core of human rights. Section 33 cannot be a blank check for governments. Otherwise, I'd say the Constitution just becomes self-defeating. One legal argument to counter Law 21 that I find compelling is the use of Section 28 in the Charter, which has received very little attention by courts. Legal feminists have argued that Section 28 is a substantive, intersectional gender equality guarantee to which Section 33 does not apply. So Section 28 says, notwithstanding anything in this Charter, the rights and freedoms referred to in it are guaranteed equally to male and female persons. So Section 28 is triggered in Law 21 because Muslim women face intersectional gender-based discrimination. That is, they are differentially denied the exercise of a charter right, in this case, freedom of religion and expression per Section 2, or the right not to be discriminated against on the basis of religion per Section 15. The Women's Legal Education and Action Fund, otherwise known as LEAF, and the National Association of Women in the Law will argue before the Supreme Court of Canada that the intersection of more than one ground of discrimination under Law 21 results in actual consequences for Muslim women who wear the veil, which do not, by definition, impact men or other distinct groups of women. So the effect of the law is to disproportionately impact a group of one gender's charter rights. The Quebec Court of Appeal unfortunately dismissed this argument, claiming that Section 28 is an interpretive provision only, and that even if it were something more, the gender equality guarantee in Section 28 is attached to the other rights in the Charter, and those rights have been rendered inoperative by invocation of Section 33. So let's see what the Supreme Court of Canada says. This case is being heard by the Supreme Court of Canada in March. I suspect that we have some judges who are going to be sympathetic to the Section 28 argument. My colleague Linda Collins and I have made another argument that seeks to put parameters around Section 33. and I'd like to tell you about that. We argue that Section 33 does not provide a blanket exemption from any constitutional obligations. And notably, Section 33 makes no mention of unwritten constitutional principles. And in our view, Section 33 is not a bottomless pit where rights and freedoms go to die. Instead, it is a limited exception that must comport with the overarching constitutional structure of the Canadian state, including the unwritten constitutional principle of protection of and respect for minorities. And in our view, these fundamental principles, which we've been told by the Supreme Court of Canada, underlie every written provision of the Constitution, including Section 33 of the Charter, and so they must be used to interpret the scope of Section 33. So for those of you who may not be up on your constitutional law, just to remind you that in a case called the Secession Reference, the Supreme Court of Canada identified 4 foundational constitutional principles: federalism, democracy, constitutionalism and the rule of law, and respect for minorities. And they said, and I quote, "These principles inform and sustain the constitutional text. They are the vital unstated assumptions upon which the text is based." That is, the unwritten assumptions are core constitutional values, and the written provisions express those values. And I would suggest that the Quebec Court of Appeal in Huck, the Law 21 case, understood the use of unwritten constitutional principles to define the scope of the law when they described Law 21's relationship to judicial independence. So, judicial independence is also an unwritten constitutional principle that guarantees that justices are free to decide honestly and impartially without concern or fear of interference from or improper influence from anyone. Now, the Court of Appeal in the Huck case said, and I quote them, "In an evident effort to respect the principle of judicial independence, Section 5 of Law 21 entrusts the Conseil de la Magistrature du Québec with the responsibility for establishing the requirements of laïcité for judges and justices." In other words, the court acknowledged, and indeed so did the legislature, that because of the unwritten constitutional principle of judicial independence, a law requiring judges not to wear religious symbols would be unenforceable, and Section 33 could not save it. So similarly, Professor Collins and I argue that the scope of Section 33 must include an understanding of our core constitutional values as reflected in our unwritten constitutional principles, and particular to this case is protection of and respect for minorities. So our argument is not that the government must justify or explain the appropriateness of the legislation's exercise of the override power per the Ford case, although many scholars have said that this would be a good idea, where a provision strips people of rights and ought to be used exceptionally. Nor do we argue that unwritten constitutional principles must necessarily be capable of invalidating legislation, contrary to the City of Toronto case. Rather, what we are asserting is that the text of Section 33 simply does not permit the undermining of core unwritten constitutional principles. And protection of minorities must assist in purposively interpreting the scope of Section 33. So this is not an argument that was made at the Quebec Superior Court or at the Court of Appeal directly. There are different interveners at the Supreme Court of Canada who are taking up parts of this argument. We'll see what happens. Let me conclude by recollecting the former Chief Justice of the Supreme Court of Canada, Justice McLaughlin. By her words, she said, "The task of judges is to do justice. Judges who enforce unjust laws, laws that run contrary to the fundamental assumptions about a just society, lose their legitimacy." She was referring, of course, to the lessons of the Nuremberg trials, but she went on to state that it is also a lesson that should embolden judges when faced with seemingly more mundane manifestations of injustice. Law 21 has been a terribly unjust law with severe consequences for many religious minorities. It is a law that undermines our values enshrined in the Constitution, both written and unwritten principles of the highest order. And these instances affect not only minority communities, but all of us. It has much broader implications for our institutions and for the kind of society that we want to live in. So thank you very much for your time.